India Legal presents Courts Roundup.
Supreme Court has allowed the central government to conduct the foundation ceremony of Central Vista project without altering the status of site in any manner, after the court slammed the central government for going ahead with the construction works of project even when the judgment on the petitions against it is awaited. The Solicitor General Tushar Mehta undertook that no construction or demolition of structures or cutting down of trees will take place.
The Supreme Court clarified that the central government is free to go ahead with the foundation stone laying ceremony of the Central Vista redevelopment project on 10th December, but cannot carry out any construction or demolition at the project site till the top court pronounces its judgment in the petition challenging the project. An order to that effect was passed by a bench of Justices A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna after the central government, through Solicitor General Tushar Mehta, undertook that no construction, demolition or felling of trees will be carried out till the top court decides the case one way or the other. The clarification was made by the Apex Court after it listed the case for hearing suo motu taking exceptions to the government's plan to begin construction activities. The Central Vista area in Lutyens Delhi houses iconic building like the Parliament House, Rashtrapati Bhavan, the North and South Block buildings and the India Gate. The petitioner before the Supreme Court have challenged a notification issued by the Delhi Development Authority DDA on 21st December 2019 regarding changes in land use for the redevelopment. In November, Solicitor General Tushar Mehta, representing the centre, had said that the current Parliament building, which was open in 1927, does not adhere to fire safety norms, has a serious space crunch and is not earthquake-proof. The building was built in 1927 prior to independence and was intended to house the Legislative Council and not our bicameral legislature we have today. The building does not conform to fire safety norms and water and sewer lines are also haphazard, which is damaging the heritage nature of the building. Once there is an increase in the number of seats of the Lok Sabha and the Rajya Sabha after the fresh census to be conducted next year, the building will be under stress, Mehta added. He had also cited security concern, highlighting the 2001 Parliament attack. Bureau Report.
The Supreme Court has refused to entertain a petition filed by Republic TV and its editor-in-chief Arnab Goswami, seeking protection for all the employees of the news channel from coercive action by Maharashtra police. The plea alleging continuous hounding of Republic TV and its employees by the Maharashtra police and seeking a probe by Central Bureau of Investigation was withdrawn after a bench headed by Justice D.Y. Chandrachud remarked that it was ambitious in nature. This petition is ambitious in nature. You want Maharashtra police not to arrest any employee and transfer to CBI? You better withdraw this, said Justice Chandrachud. Goswami's counsel, senior advocate Milind Sathe, then chose to withdraw the plea after the court granted liberty to Goswami and Republic TV to move appropriate forum for relief. The Supreme Court refused to quash the FIRs filed against television anchor Amish Devgan for making derogatory remarks against a Sufi saint. The court has also directed that all the FIRs filed against Devgan in different states be transferred to police station in Ajmer. The interim protection from arrest earlier granted to the anchor will continue, subject to his joining the investigation. Several FIRs had been lodged against Amish Devgan in Rajasthan, Maharashtra, Uttar Pradesh and Telangana after the use of derogatory term for the Sufi saint on his debate news show. He later tweeted an apology saying that he was actually referring to Muslim rural Alauddin Khilji and inadvertently ended up naming Chishti instead. One of the primary questions before the bench was whether there was mens rea in the act of invoking Khwaja Chishti's name on the show. The bench also pondered upon whether the apology tendered by Devgan over Twitter and through a video message was an afterthought following criticism on social media or whether it was an honest face-saving exercise. The top court had granted protection to Devgan from any coercive action in any connection with the FIRs. This protection was subsequently extended from time to time. Central government has informed the Delhi High Court that transgenders shall be now included as a separate gender category in prison statistics report prepared by the National Crime Records Bureau. A statement to this effect was made by Additional Solicitor General Chetan Sharma before a division bench of Chief Justice D.N. Patel and Justice Pratik Jalan. The court was hearing a PIL by Karan Tripathi seeking inclusion of separate data on transgender prisoners in NCRB reports. ASG Sharma stated that NCRB has issued a communication informing that it intended to classify prisoners as male, female and transgenders from its report. Prison Statistics India 2020 onwards. Officials have been directed to prepare for collaboration of data accordingly, NCRB has said. In view of the above decision, the PIL was disposed of. On the last date of hearing, the court had asked the central government to come back with instructions with regards and pending representation of the petitioner. Prima facie, the prayers are very pertinent and reasonable, the court had said. The petitioner had argued that to ensure equality and protection under Articles 14, 15, 19 and 21 of the Constitution of India, it was imperative to categorize the third gender or transgenders as a separate gender in prison statistics. Relying heavily on the Supreme Court's verdict in Nalsa versus Union of India, the petitioner argued that unless transgender inmates were recognized, the guidelines passed by Supreme Court to protect their rights could not be implemented. Over 80 advocates, mostly practicing at the Delhi High Court, have made a representation before the Chief Justice of Uttarakhand High Court against denotification of the Shivalik Elephant Reserve for the purpose of developmental activities. The Shivalik Elephant Reserve is the only elephant reserve in the state of Uttarakhand, spread over 5,000 square kilometers in 14 state forest divisions. It was notified in the year 2002 under the Project Elephant, which was launched by the Government of India in the year 1992 as centrally sponsored scheme. On November 24, the Uttarakhand State Wildlife Board, in a meeting chaired by CM Trivendra Singh Rawat, denotified the reserve for expansion of Jolly Grant Airport.
Over 80 lawyers practicing before various courts in India have registered concern over the Uttarakhand government's decision to denotify the Shivalik Elephant Reserve to expand the Jolly Grant Airport. In a letter dated 1st December, the lawyers have urged the Chief Justice of the Uttarakhand High Court to take suo motu cognizance in the matter and quash the 24th November notification issued by the State Wildlife Board to denotify the Shivalik Elephant Reserve. The letter places on record the deep concern of the lawyers over the reckless decision to denote reserve following a meeting chaired by the Chief Minister Trivendra Singh Rawat on 24th of November. The decision prima facie appears to be hasty and short-sighted and taken without due consideration for the natural environment and wildlife conservation. Despite the ongoing reality of climate change and rapidly rising pollution, reads the letter. It adds that the proposed development expansion activity will threaten hundreds of species of fauna and elephant corridor and increase man-animal conflict. It would also require felling at least 10,000 trees and exacerbate soil erosion risk, it is stated. As such, the lawyer highlighted that in moving ahead with the proposal, the state has completely lost sight of its duties and obligations under the construction to protect and improve the environment. It is pointed out that the High Court itself has accorded the status of legal person to animal, conferring on them distinct rights and declaring the natives of Uttarakhand obliged to ensure their welfare. More recently, in Hospitality Association of Madhumalai versus in Defense of Environment and Animals and ORS, a division bench of the High Court, also reaffirmed the right of passage of animals and the closure of resorts in environmental interest. It is recalled. In this backdrop, the lawyer have now urged the Chief Justice to similarly intervene in the present issue and set aside the denotification of the Shivalik Elephant Reserve and to protect the wild elephant in the state of Uttarakhand. Bureau Report.
The Karnataka High Court has directed the state government to clarify whether it was willing to issue a public notice that the Kovri Calling project is the project of Sadhguru Jaggi Vasudev's Isha Foundation and Isha Outreach and that the government has nothing to do with it. A division bench of Chief Justice Abhay S. Oka and Justice S. Vishwajit Shetty said, "Entire grievance is that respondents are projecting that they are implementing a government project. You must clarify and put an end to it by issuing a public notice and the matter will end." The bench directed the state government to clarify its stand. The direction was given while hearing a petition on objection over Sadhguru Jaggi Vasudev's Isha Foundation, collecting funds from public for the Kovri Calling project. Earlier, the government had told the court that Kovri Calling was the project of the state. As per the petition, the foundation is planning to plant 253 crore tree saplings across 639-kilometer stretch of Kovri river bank. The foundation is said to be collecting rupees 42 per tree planting from the public. That means it is collecting rupees 10,626 crores, which according to the petitioner is a major scam. On January 7, the court had asked the foundation to disclose the amount it had collected for the Kovri Calling project. The Karnataka High Court had asked the state to recover losses caused to small traders and roadside businesses during the bandhs from organizers of such demonstrations. The court was apprised that Karnataka bandh was scheduled on December 5. While refusing to pass an interim order on the bandh call, the court stated that Kannada Chaluvali Vatal Paksha, the organizer of the bandh, is yet to respond to court's notice. The court was hearing a plea alleging that the National Directives for COVID-19 Management, part of the Union Ministry of Home Affairs guidelines, were not being followed in Karnataka. During the course of the hearing, the bench directed the state government to impose fines on individuals and higher penalties on organizers of rallies as part of Karnataka bandh on December 5. If they violate COVID-19 norms. The bench further noted that state had not taken steps to prosecute those violating face mask and social distancing regulations during protest and rallies. Also, it was pertinently observed that the state had not passed an ordinance to amend the existing penal provision under the Karnataka Epidemic Diseases Act, which only penalizes the violators to extent of collecting fines. The bench additionally directed the government to ask the police department to keep a vigil on the violators during the bandh. Taking note of suicides and desertions within the police force, the Madurai bench of Madras High Court raised concern over the welfare of police officers in the state, observing that policemen are made to work round the clock without a break. This court can take note of fact that police is working round the clock without a break, Madras High Court said. For action, police is blamed. For inaction, police is blamed. Police are like orphans. Bench said that it is aware of serious allegations against policemen, including in the recent custodial death cases. While so, policemen are not allowed weekly holidays, proper sleep or rest, or even to go to their children's birthdays or social functions, the judge remarked. Over 500 desertions have taken place in the police force in the recent times, the bench observed, as have suicides within the force. All this goes to show that uniformed persons are under stress physically and physiologically, the court opined. As per his 2013 ruling, the commission was to be headed by a retired High Court judge and include a psychiatrist, a general physician, a sociologist, and IAS officer, an IPS officer, and an advocate engaged in service law. The commission was tasked with examining the problems faced by the police and recommend measures to resolve the same. It is not known whether this commission has been formed, the bench noted. Only family members or near relatives of deceased person can file a suit for defamation under Section 499 of the Indian Penal Code. The Punjab and Haryana High Court has held. On that ground, a single-judge bench of Justice Sanjay Kumar quashed a defamation complaint filed by an unrelated person against late Arya Samaji, one Sant Kanwar and a follower of prominent Arya Samajis and freedom fighter and the grandfather of former Chief Minister Bhupinder Singh Hooda, Chaudhry Matu Ram Hooda, filed a defamation complaint against former Member of Parliament Rajkumar Saini. Kanwar claimed that Saini had made certain defamatory remarks against the late Maturam Hooda. Based on Kanwar's complaint, the magistrate had issued a summons to Saini. The High Court said in reference to Section 499 of the Penal Code and noted that only a person aggrieved could file a defamation suit. The court additionally emphasized that an imputation made against a deceased person could also amount to defamation, but that only a relative or a family member could file the defamation suit in respect of an imputation against a deceased person. The Punjab and Haryana High Court on Thursday last heard a plea asking why there were separate and different cremation grounds for Brahmins, backward classes and Sikhs in village in Ambala district. The petitioner's applicant filed earlier on September 11 this year was rejected by an order passed by Deputy Commissioner. The division bench of Justice Jaswant Singh observed in its order that 5 cremation grounds were already existing and earmarked for different communities, and as such it deemed it appropriate to seek a response from Ambala Deputy Commissioner on such divisions of society. The council appearing for petitioners sought directions to Deputy Commissioner and another responded to restore the cremation ground belonging to them and other residents belonging to Brahmins and backward classes. The court was hearing the plea of one Jaswant Kumar and 7 other villagers who claimed before the court that Brahmins, Sikhs and backward classes had separate cremation grounds in the area of village in Ambala district. Petitioners and other members of the community claimed before the court that they were left without the right to perform the last rites of departed souls, as all 5 cremation grounds in the village were community-wise. An argument by the police that CCTV system installed in police station was not working cannot be accepted since it would defeat the very purpose which the same was installed, the Bombay High Court's Aurangabad bench recently said. The court was hearing a plea alleging a custodial harassment by the police. The petitioner, W.M. Sheikh, had submitted that the police station was not providing a copy of CCTV footage despite his application for the same. Bombay High Court said that CCTV system controlled atrocities against people brought to police stations, holding that this was not the first time they were informed the CCTV system was not working. The court observed that an officer should be appointed to oversee the working of the system and to maintain a register about the same after inspecting the CCTV records every day. Since no such record or register was produced in the instant case, it created suspicion against police station in question, the bench observed. It, therefore, ordered District Superintendent of Police, Osmanabad, to look into the matter personally and hold an inquiry into the matter and submit a report to the court. The Allahabad High Court has opined that charging a person who participated in Tablighi Jamaat convention at New Delhi with offence of attempt to murder under the Indian Penal Code prima facie reflected an abuse of the power of law. The High Court made observation while staying the criminal proceedings under Section 307, attempt to murder, and 270, malignant act likely to spread infection of disease dangerous to life, of the IPC against the Tablighi Jamaat attendee. The prosecution claimed that accused went to Delhi knowing fully well that COVID-19 pandemic had been declared and that a large number of persons at the Markaz congregation at New Delhi were infected. It was alleged that the petitioner and others accused had concealed their visit to Delhi and deliberately indulged in negligent and condemnable acts. Advocate Javed Habib, appearing for the petitioner, however, contended that even if the evidence collected during the investigation as well as the FIR were taken on their face value, no offence was disclosed against the applicants. Noting that the matter required consideration, Justice Bhanot has directed the concerned SSP and CO to file a personal affidavit in the matter to explain how offence of attempt to murder has been attracted in this case. That's all for Courts Roundup today. Keep watching APN.
India Legal presents Courts Roundup.